Thank you very much. Hello, I'm Saira Paruk. I'm a barrister at Quadrant Chambers and I've been practicing in commercial law and international arbitration for over 15 years. This QBiT talk is how to appeal an arbitration award. Just by way of background, I'm referring to arbitration awards where the Arbitration Act 1996 applies, so where the seat of arbitration is England and Wales or Northern Ireland. So, what do I mean when I refer to appealing an award? I mean an appeal on a point of law provided for by section 69 of the Act. It's not a challenge of the award on a question of substantive jurisdiction, nor is it a challenge of the award for serious irregularity. Those are topics for another day. A section 69 appeal is available either with the consent of all the parties, which is very unlikely to be granted, or with the permission of the court. So I'll look at this in 3 stages. First, before you make the application for permission. Second, the application for permission itself. And thirdly, and briefly, what happens if you get permission. First, check that the right of appeal under section 69 has not been excluded from the arbitration agreement. Section 69 is not mandatory, so parties can contract out of it. Some institutional rules, such as the ICC and LCIA rules, restrict the right to appeal. Second, check that there is no other process of appeal or review which can be used. This could be specific to your tribunal or process, or pursuant to section 57 of the Act, where clarification or correction of an award can be sought. Thirdly, do you need permission to serve out of the jurisdiction? You need to check what you need to do. And fourthly, and possibly most importantly, be mindful of the time limits. As per section 70, subsection 3, you have 28 days from the date the award was published. That is not the date when the parties pay the tribunal and receive the award, it is the date the award was available. Although time extensions can be applied for, it is dangerous to rely on that as a default position. So, turning to the application for permission itself, when will the court grant permission? As set out in section 69, permission will only be given if the court is satisfied that, first, the determination of the question will substantially affect the rights of one or more of the parties. Second, the question is one which the tribunal was asked to determine. Third, on the basis of the findings of fact in the award, the decision of the tribunal on the question is obviously wrong, or the question is one of general public importance and the decision of the tribunal is at least open to serious doubt. And finally, you have to show that despite the agreement of the parties to resolve the matter by arbitration, it is just and proper in all the circumstances for the court to determine the question. Before moving on to the specifics of those threshold tests, I'll briefly look at the practicalities of how you actually apply. The applicant issues a claim form which sets out its position, similar to a pleading. Secondly, you need a skeleton argument. This needs to deal fully with your position, as the permission stage is on paper and there's no leeway to elaborate or emphasise in oral submissions. This is your one shot, so you need to make it count. You can also submit a witness statement, but this is restricted to satisfying the statutory tests. And other documents you can include are the award and possibly submissions, but again, only if it's strictly necessary. Turning back to the threshold tests, the first, you must show that the determination of the question will substantially affect the rights of one or more of the parties. This will be satisfied as long as the question is not trivial, academic, or of marginal importance. The question must have a real effect on the outcome of the case, for example, affect the damages awarded. The court will not entertain an appeal which in the end makes no difference to the parties' interests. The second threshold test, that you must show that the question is one which the tribunal was asked to determine. This is one of the simpler tests, and you just need to show that the issue of law was put to the tribunal. It should be evident from the award, but if not, other arbitration documents can be appended to the claim form, or it can be addressed in a witness statement. The question does not have to be in exactly the same form in which it was posed in the arbitration. Instead, what the courts consider necessary is that the question of law is inherent in the issues for decision by the tribunal. The third threshold test, and this is the crux of it really, is that you have to show that on the basis of the findings of fact in the award, the decision of the tribunal on the question is obviously wrong, or the question is one of general public importance and the decision of the tribunal is at least open to serious doubt. That was quite a mouthful, so I'll break it down. The first point is it must be a question of law, not fact. It's clear that the tribunal's findings of fact are assumed to be correct and will not be revisited. It does cover the case where the tribunal errs in ascertaining the legal principle itself. And questions of construction of a clause or the contract can also qualify. But it does not include the case where a tribunal sets out the correct legal principle but applies it incorrectly. And finally, a question of foreign law is not considered a question of law at all. It is an issue of fact. The next point to consider is whether your question is one of general public importance. This is an important question because it will lower the threshold that you have to meet. You only have to show that it's open to serious doubt rather than obviously wrong. To show that it's of general public importance, you should consider whether it raises a question of construction of a clause in a standard form contract. Alternatively, if the factual circumstances have given rise to a large number of similar claims, that could make it a question of general public importance. But bear in mind that even if the parties agree that it is in the public interest for this question to be considered, if the facts are highly unusual, a court is unlikely to agree. So if you're stuck with a one-off case, the test you have to meet is that the decision was obviously wrong. What does that mean? The courts have used various phrases to explain this. For example, they have said the answer given by the tribunal is, in all the circumstances, outside the permissible range of solutions open to arbitrators. They've also said that it has to be apparent upon a mere perusal of the reasoned award itself without the benefit of adversarial argument that the meaning ascribed to the clause by the arbitrator is obviously wrong. Though perhaps the best, most relatable approach was apparently stated by a judge in a master's lecture, who said that a decision that is obviously wrong is one that can be understood as such over a good bottle of Chablis and some pleasant smoked salmon, and not on the 12th reading of the clause. If you can show that it's a question of general public importance, then you have the lower threshold to meet, which is that the decision was at least open to serious doubt. This test should be easier to meet, but it is harder to articulate. The courts have gone so far as to say that it is a test which is broader than obviously wrong, but in one case it was found that where 3 experienced arbitrators disagreed on the question, that meant that it was open to serious doubt. The final threshold test, so once you've shown the determination of the question is obviously wrong or open to serious doubt, you still have to show that despite the agreement of the parties to resolve the matter by arbitration, it is just and proper in all the circumstances for the court to determine the question. If all the other conditions are met, this is likely to be satisfied too. However, the court does get an overriding residual discretion to refuse your permission at this stage. Things that the court may look at are the expertise of the arbitrators, or the parties' agreement to hold a quick arbitration, or if the contract provides that the award is to be final and binding. All of these could scupper your application. So, if you get permission to appeal, what happens next? You have a hearing of the substantive appeal and additional skeleton arguments can be submitted. The court can then confirm the award and thereby dismiss the appeal. It can vary the award, or it can remit the award to the tribunal in whole or in part for reconsideration. They can also set the award aside in whole or in part. Though you should note that under section 69(7, the default position is that the court should not set aside an award in whole or in part, unless it would be inappropriate to remit matters to the tribunal's reconsideration. So the default position is that it will be remitted. And that, ladies and gentlemen, is how to appeal an arbitration award.